HB number 15 by Hefner, relating to certain files maintained by a law enforcement agency regarding certain employees of the agency.
Chair recognizes Mr. Hefner.
Thank you, Mr. Speaker. Members, right now there's no consistency among law enforcement agencies regarding what files are made public and what files are not made public. Civil service cities, those that have adopted Chapter 143 of the Local Government Code, currently maintain both a separate personnel file and a department file for every officer. Chapter 143 requires the following documents to be held in the personnel file: substantiated misconduct complaints, commendations, congratulations, and/or awards bestowed on the officer, and periodic evaluations of the officer by a supervisor. All other documents not required to be held in a peace officer's personnel file must be held in their department file. This includes unsubstantiated misconduct complaints against an officer. Those are complaints that did not result in disciplinary actions, which means those that do not rise to the level of disciplinary action, training memos, counseling, coaching documents, and background hiring information. In response to a recommendation by the Sunset Commission, TCO commissioners adopted a model personnel department file policy for all law enforcement agencies that substantively mirrors the requirement of Chapter 143 for civil service cities. HB 15 codifies this model policy to prevent any conflict with current law. I want to stress HB 15 only affects requests for disclosure under the Public Information Act. If someone is suing a law enforcement agency or officer, they will still have access to documents in the department file via discovery as required by law. This is true for a prosecuting attorney attempting to access files, suppress criminal charges against an officer, defense counsel, and other police agencies. Additionally, this bill will not affect disclosure requirements under the Michael Morton Act or the Sandra Bland Act. Senator King accepted an amendment on the floor, and we incorporated the substitute here that clarifies for the purposes of accountability and transparency of those specific acts. Mr. Speaker.
Mr. Speaker,
Mr. Tinderholt, for what purpose?
the gentleman yield for question.
Will the gentleman yield for questions?
Yes.
So I've had
Gentleman
several
yields.
people reach out, and they're trying to get a lot of people to vote against this, and I know your intent. Is the intent of this bill to try to hide what police officers do on a daily basis, or is it to protect good acting police officers?
It's to protect the good actors. This is a model policy developed from the 2023 session, and there was a committee formed of sworn and non-sworn individuals, defense attorneys, district attorneys, and they went all over the state and put this work product together. This is model policy that's been used by DPS for 30 or 40 years, and 26,000 officers currently operate under the provisions of this bill.
And if someone's disciplined and there's an issue with that police officer, will people be able to find those issues under this law?
Yes, if there is disciplinary action taken, that is subject to open meetings.
Thank you very much.
Mr. Speaker,
Mr. Moody, for what purpose?
ask the gentleman some questions.
Will the gentleman yield for questions?
Yes, I yield.
Gentleman yields.
Thank you, Mr. Hefner. I appreciate it. And I know we've had a number of conversations about this, and I certainly appreciate the time that you give me. I want to go through a few things, and it kind of pivots off of what Mr. Tinderholt said right now, because you're talking about substantiated claims versus unsubstantiated claims, right?
Right.
And so I think the conversation around your rank and file officers is that you have an unsubstantiated claim, and now somehow that's essentially being lodged against them in court. They were found to have acted properly, or whatever the case may be. And so now, like if you and I were accused of something and it was dismissed or went away, we wouldn't want someone then kind of coming after us with that information. That's kind of the crux of what we're going after, right?
Correct. On that specific issue of
Yeah.
unsubstantiated claims, yes.
And so this is the part I just want clarity on, because I think at least the concerns that I've had, and I've concerns of some folks that I've talked to, is there's the investigation into someone in how they, let's say, how they dealt with a member of the public. And they go through that investigation, and that's unsubstantiated. The concern I have is the information that's not the information about the complaint and the investigation of the complaint. If it's unsubstantiated, I agree. Then we can set that aside. I'm trying to look at the underlying facts of the interaction with the public. So things like body-worn cameras, the dash cam videos, things that, the recording devices that officers routinely use now for both their protection and the public's protection. Mm-hmm. Those are not things that are going to go in the department file, are there? Or is that your intent for the underlying incident
No.
videos to go into the department file?
No, absolutely not. The body-worn footage and dash cam footage are in the personnel file. They are governed by their own specific code, and so they would not fall into the department file.
Is there anything that prohibits an agency from? Because you're telling me what your intent is, but we all have a lot of intent when we write these, and then something goes on out there in the field. Is there anything here that prohibits the underlying incident that was investigated? I'm not talking about the investigation into the officer, because we've decided that we want to leave, that's outside the public's eye. But like the incident itself with the public, those videos, those 911 calls, those dash cam videos, is there anything that prohibits an agency from directing those into a file that is now not subject to public information?
No, the body-worn camera footage that is or could be used as evidence in a criminal prosecution would still be disclosable under the Public Information Act, and that's pursuant to the Code of Criminal Procedure, Article 2B-0112.
Okay.
That is what polices or governs how that camera footage is stored and that it is disclosable to the public.
And this is some of the clarity that I want to have with you. So we think about reports that come along with police interaction. So incident reports, the traffic stop reports, they have to file use of force reports, et cetera. Those are not permitted to be placed in this department file either, right?
Correct, that's my understanding. And keep in mind, what we're doing is we're taking the portion of Chapter 143, which, by the way, the original 143 was adopted in 1943. This is the gold standard of how these records are kept and stored that's been on the books for years. Now, obviously, it's probably been updated through the years, but it's been used by DPS for 30 or 40 years, and it's been used by these 26,000 officers across the state.
And so that's what I want to be clear about, because the thing that I don't want to be conflated here is there's the investigation into the officer for whatever the conduct is that they were accused of, and that's either substantiated or not. What I don't want to lose when something's unsubstantiated are the core records, the incident report, the traffic report, use of force report, the 911, the body cam video, the dash cam video, the recording on the lapel pit, all that stuff. All that stuff is still public record, and you're not permitted, like this bill does not permit these things to be placed in the department file, which has a bar on public information.
No, you're correct.
Okay. And a question on if and I see the sheriff standing next to you, so it reminds me, he was a peace officer. He's also an elected official. He was a license holder, peace officer, also elected. And then you have department heads, right? So you have sheriffs, you have constables, you have department heads, the police chiefs, right? Those are people at the top of the agency. I know that, do you think we should have a different standard here for elected officials or department heads versus our rank and file officers?
I personally do not. I think when they take their oath of office, their oath to protect and serve, that the same rules should apply to them.
What if someone is they're a license holder under the statute, and they hold elected office otherwise, So county commissioner, city council, whatever the case may be, are they going to be able to avail themselves of these protections?
If they're acting in the duties, I'm being told a commissioner, like a county commissioner would not, but an acting sworn officer would be under these protections.
But they can keep their license, right? Even if they're elected.
Yeah, I know some
one of
people
these
that
other
have kept their
positions?
license, but I don't know that they're a practicing officer, like they're not active.
Do you think there's a difference in the level of public scrutiny that we should have over someone who is an elected official license holder but is not in the law enforcement business anymore?
I think if they were, when acting in the duty of a peace officer, they should be held to the same standard. I don't really understand the benefit of just putting an elected title beside their name would put them in a different box. I don't know how that would be applied. So the same standard would apply to all peace officers.
Whether they hold another office of public trust or not.
That's correct.
Okay, and you think that's
I think the level of scrutiny and the level of oversight and reporting and training and the things that we put on our officers all the time is adequate to hold them accountable.
No, and I know.
I don't know that increasing the requirements or the just because they're elected, even though they may not be active, I don't really understand the purpose that would serve. But this bill would not do that.
It would still offer them those same protections.
I guess if they were acting in the duties of a peace officer, but if they're not, if they're just out there being a county commissioner, then no, I don't believe it would apply to their commissioner duties.
But
Is that what you're asking? Like in their,
what I'm trying to get at is, does the public in that circumstance, when someone has decided to take on a position of public trust, should they not have a higher bar of scrutiny? Because I think what you're doing here is you're looking at your rank and file officers that, and I'll just accept what you're saying. And I as a prosecutor, I dealt with these when you had officers that had issues and the defense attorneys would go after them on the stand based on whatever we had to disclose. And so I get the concern, but when someone steps into or attempts to step into a position of public trust, I would think that the scrutiny level will be higher, but I don't think there's nothing in here that would lift the veil for someone who's now stepping into a different position of public trust.
well, when you talk about a position of public trust, to me, that the position of public trust and the burden that's put on a law enforcement officer in many ways is higher than elected official, because they're out there enforcing the laws, sometimes by force if somebody doesn't comply. And so I think we're getting this kind of backwards here. We already have such a high bar on our peace officers. I don't know how we would make sense of an even higher bar because they're elected, because they've already got a higher bar than electeds already. So, sheriffs, elected people that are certified peace officers have the same standards as other officers.
Well,
And
what
I
I'm
just-
saying is the level of scrutiny, because the rationale behind this is to protect our rank and file officers from, unnecessary relitigation of things that have
Right.
been unsubstantiated. But when someone avails himself of seeking a position of public trust, you would agree with me that the public deserves to know more in that situation.
More of what?
Well, more information. They're seeking now they get to be provided with these levels of secrecy on these types of claims that are unsubstantiated, and there's no later change in that
I
if
think
they
if you-
seek another position of public trust and they're still a license holder.
I
Or were a license holder when
I believe
this-
the same standards should apply. I don't believe we should pick and choose different levels of scrutiny.
All right. I appreciate your time. Thank you, sir.
Yes, sir.
The following amendment, the clerk will read the amendment.
Amendment by Moody.
Chair recognizes Mr. Moody to explain the amendment.
Thank you. Thank you, Mr. Speaker. Members, I know it's been a long day. I also know this is an amendment that I spoke about at great length the other day when we saw this as a Senate bill, and it does the same thing. It preserves the closure of the dead suspects loophole that was passed by this body last session in House Bill 30, and I do believe now it is acceptable to the author. So I move adoption.
Mr. Moody sends up an amendment. The amendment is acceptable to the author. However, a record vote has been requested. The clerk will ring the bell. Show Mr. Hefner voting aye. Show Mr. Louderback voting aye. Have all voted? There being 125 ayes, 0 nays, the amendment is adopted. The following amendment, the clerk will read the amendment.
Amendment by McLaughlin.
Chair recognizes Mr. McLaughlin to explain the amendment.
Thank you, Mr. Speaker. Members, as written, House Bill 15 would close off access to critical records after tragedies like the shooting at Robb Elementary. My amendment makes sure that complainants, officers, and most importantly, the families of victims will still have access to these records once investigations are complete. At the same time, it includes strict safeguards to prevent duplication or misuse. This amendment is for my hometown of Uvalde and for the Robb families who are still waiting for answers. 3.5 years, and they still don't have answers. My amendment does not change this bill. What it says, a person permitted to view letter, memorandum, or document under subsection F1 may not duplicate, record, capture, or otherwise memorialize the letter, memorandum, or document. A permitted viewing of a letter, memorandum, or document under subsection F1 is not considered to be a release of public information for purpose of Chapter 552 Government Code. And I can tell you, as the mayor of Uvalde, there were 4 investigations done on that shooting. 3 of them you can take and throw in the trash can. The only honest and true facts that you saw was the investigation that was done by this House in the 87th legislature, led by the Speaker and Mr. Moody. It's been the most truthful one that's been written to this day. And I can argue with anybody that wants to say it's not, because I was there that day, and I have to live with that day the rest of my life. I can't change it, can't do that. But these families have the right to know what happened that day. This amendment still protects the officers and their information. It just gives these families or complainants the ability to view those records themselves. Not copy them, not publish them, not print them, just to view the records and find out what went on that day. So, and with that, I've got a letter that the Robb family asked me to read, Lives Robbed. And I told them I would read it. I think they're owed that much and more. In wake of the tragedies like the one we experienced in Uvalde, transparency is not optional. It is essential. Senate Bill 15 threatens to block families and the public from accessing vital information about police conduct and accountability. Without that access, there is no way to ensure law enforcement upholds the highest standards of professionalism and integrity. Senate Bill 15 would hide police actions from scrutiny, making it harder to uncover misconduct, address systematic failures, and demand accountability when officers fall short. Secrecy does not build trust, it destroys it. Lives Robbed calls on the legislature to reject SB 15. Texas cannot afford laws that protect institutions over people. We must choose transparency, accountability, and reform to protect communities and to honor those we have lost by working to prevent future violence. That was written by Kimberly Mata Rubio, Lexi's mom and president of Lives Robbed, representing the families. With that, I move adoption.
Mr. Speaker,
Mr. Little, for what purpose?
does Representative McLaughlin yield for a few
Will
questions?
the gentleman yield for questions?
Yes.
The gentleman yields.
Representative McLaughlin, thank you for offering this amendment. I know Chairman Hefner has worked extremely hard on this bill and has brought it several times and in several iterations. Obviously, I don't know whether he intends to accept this amendment or not, but it seems to me that the tension that has arisen on the right and on the left in this chamber is over who should have what information about law enforcement. And on one extreme, we have people saying we must have transparency, we must have sunlight to be able to look at what occurs in law enforcement. On the other extreme, we have people saying we must look out for law enforcement officials and protect their reputations when there are unsubstantiated allegations. It seems to me that the purpose of your amendment is to ensure that information is provided to families who are impacted by law enforcement in some negative way without requiring the dissemination of that information out to the general public. Is that what you were going for here?
Yes, most definitely.
And you'll have to excuse my ignorance over not knowing everything that the families in Uvalde have gone through, but it seems to me they've been trying to obtain information and have been unable to do so for some period of time. Is that right?
It's 3.5 years and still fighting right now for information.
What specific information is it that they want that they've been unable to obtain?
Well, the DA won't release it and keeps using an investigation. We've already had a criminal investigation. 2 officers were indicted out of 391 there that day. Two years later, they just want to know what the actions were, what the report says these officers did. Look, I was there that day. Were bad decisions made? Most definitely. Poor judgment used? Most definitely. Do I think what was done that day was criminal? I do not. I do not think what those officers did. I think poor judgment was used in that, but I do not think it was criminal. But these families that lost 19 kids and 2 teachers, they have a right to know what happened that day or what the actual report says. And like I said, there's been 4 reports written. 3 of them you could throw in the trash can. The most honest one has been the one that came out of this house.
I see. It seems to me that one of the painful reminders that those families have to have is that they're seeking information that some law enforcement agency is putting in a box where other people can't obtain it, whether it's under an investigative privilege or some other place. But it seems to me that one of the concerns raised in the bill is that the same type of information those families are seeking to obtain will simply go into a department file where it will once again be unobtainable. Is that your
Is correct.
assessment?
Once they see it, it goes back into that document. It's not unless there's a lawsuit filed, that material will not be open to the public.
Well, I appreciate very much your thoughtful amendment, and I hope we'll have the opportunity to vote on it. Thank you.
Thank you.
Mr. Hefner in opposition.
Members, I've gotten to know Representative McLaughlin the last few months, and he's one of my favorite people in this chamber. He's a man of integrity, and he has a great heart for his people, and he's served on Homeland Security and Public Safety Committee with me, and he was a great member and ally there. About the unfortunate events that happened in Uvalde, this bill would in no way hide any of those records. Those records have not been kept from the public eye by law enforcement officers. They have been sealed or withheld by the district attorney in Uvalde. This bill seeks to apply statewide model policy that already applies to 28,000 police officers across this state. This is policy that we directed TCOLE to develop, and they spent 2 years developing a statewide model policy so that we have uniformity and consistency across the state. So those events at Uvalde and other shooting incidents are not going to be withheld under provisions of this bill. Again, those are not being held by the law enforcement agencies. It is the district attorney of Uvalde that is withholding that from the public. So with that, I respectfully move to
Speaker.
table this
Mr.
amendment.
Moody, for what purpose?
Will the gentleman yield for questions?
Gentleman yield for questions?
Yes.
He yields for questions.
Thank you, Mr. Hefner. And I think you heard in Mr. McLaughlin's layout of this amendment make reference to the House Investigatory Committee report in the wake of the tragedy at Robb Elementary. You heard that part of his remarks.
Yes, sir.
Do you know why our report was the most accurate report to date and is held up against scrutiny to this very day?
No, sir.
Because we had all the information, terabytes of it, stuff that I never wanted to see, never wanted to read. But it was our job to do that for the families. And the reason we did our job is because we had complete access to everything. That's why.
Members, again, these records are not being held by law enforcement officers. They're being withheld by the district attorney in Uvalde.
Speaker,
Speaker Irvin Hawkins, for what purpose?
will the gentleman yield for a question?
Gentleman yield for questions.
Yes.
Representative Hefner, I'm trying to understand. We're saying we want transparency, and you're against a amendment that will add transparency?
I'm against what I'm trying to do here. What we're trying to accomplish is to protect our officers, people who wake up every morning, and they put on a bulletproof vest to go to work. And unsubstantiated claims, hiring background information that has to do with their private family members should not be disclosed to the public. What happened in Uvalde is a horrible, tragic event. But this bill does not hide any of those records. It would not whatsoever. That is being withheld by the district attorney of Uvalde, not law enforcement officers. And so we're talking about viewing the personal information of peace officers who get up every day. Do you put on a bulletproof vest to go to work every day?
Representative Hefner, please don't come at me like that.
Do you?
Matter of fact, I got family members that are police officers.
I do too.
So I do understand the
I do too.
gravity, sir.
And I don't want to see these slimy lawyers out here all over this state use this file to impugn men and women that put on a bulletproof vest to go to work every day to keep the rest of us safe.
Mr. Speaker, can I ask the gentleman questions, or he wants to preach about his side?
Members, please take your conversations outside the rails.
So, Representative Hefner, are you willing to answer questions, or? So
Ask away.
So my question is related to, I appreciate police officers too, and then you say TCLO worked 2 years to craft something. So the people who have the information have said, let's seal the records. And that's okay with you?
This is already, Ms. Gervin Hawkins, this policy already applies to 28,000 law enforcement officers across this state. We're not doing anything new. This has already been done for decades by 26,000 officers across this state. We're trying to balance transparency and due process and protecting the information.
Thank you, Representative Hefner. Thank you.
So be it. No, I'm not. Members, I respectfully move to table.
Okay. Mr. McLaughlin sends up an amendment. Mr. Hefner has moved to table. This is a division vote. Clerk, ring the bell. Record vote has been requested. Record vote is granted. The clerk will ring the bell. Have all members voted? Have all members voted? 19 ayes and 107 nays. The motion to table fails. The amendment is acceptable to the author. Is there objection? Chair hears none. The amendment is adopted. Is Ms. Jones of Harris on the floor of the House? Anyone wish to speak on, for, or against House Bill 15? Mr. Hefner to close.
Move passage.
Question occurs on passage of House Bill 15 engrossment. Record vote. Clerk, ring the bell. Have all members voted? Have all members voted? 87 ayes, 41 nays. House Bill 15 passes to engrossment.